The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting.
Thank you. Please be seated. Good morning. Welcome to Oral Arguments in the Kansas Supreme Court. I'm now going to call upon Carol Green, as Clerk of the Supreme Court, to do the honor of calling this morning's docket.
Appeal number 105,057, State of Kansas versus Hilt, Johnson County,
Please the court, Joanna Labastida of the Kansas State Attorney Office for Mr. Dustin Hilt. We are prepared for argument.
May it please the court, the state of Kansas appeared by Steve M. Howe, Johnson County District Attorney. We're ready to proceed.
Appeal number 105,828, State of Kansas versus Cameron, Central County, versus both sides.
My name is Randall Hodgkinson. I'm here today on behalf of Mr. Cameron, and I'm ready for argument.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state of Kansas, ready for argument.
Appeal number 105,091, State of Kansas versus Rimmert, Butler County, agrees both sides.
May it please the court, Corey Call, representing Thomas Rimmert, present, ready for argument.
May it please the court, Darren C. Devaney, Butler County Attorney on behalf of the state of Kansas, prepared for argument.
Appeal number 104,245, State of Kansas versus Smith, Bourbon County, agrees both sides.
May it please the court, Meryl Carver-Allman, Capital Appellate Defender, on behalf of Mr. Smith, present and ready for argument.
May it please the court, the state of Kansas appears by and through Bourbon County Attorney Terry Johnson, ready for argument.
Appeal number 105,934, State of Kansas versus Kelly, Johnson County, agrees both sides.
May it please the court, Carl Folsom III for Mr. Kelly, the appellant. I'm ready for argument.
May it please the court, the appellee, State of Kansas, appears by Stephen J. Obermeyer, Assistant District Attorney, ready for argument.
That concludes the main docket, Your Honor.
Thank you, Ms. Green. Now turn our attention to the first case on this morning's docket. That is case number 105057, State of Kansas v. Dustin B. Hilt.
May it please the court, Joanna Labastida of the Kansas Appellate Defender Office for the appellant, Mr. Dustin Hilt. If I may, Your Honor, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. And unless the court would prefer otherwise, I'm just going to dive right in with issue 1. The first issue is that the district court erred in denying Mr. Hilt's request to supplement the aiding and abetting instruction. Mr. Hilt did request this instruction, so this court reviews the district court's refusal to give that specific instruction. Must consider the evidence in light most favorable to the party requesting the instruction.
And what's the evidence you have that would support us ruling that it was a factually appropriate thing to do?
It was a bit of a different situation in that there were 3 co-defendants. It seemed that the forensic evidence pointed more towards one of Mr. Hilt's co-defendant as the main perpetrator of the stabbings. The forensic evidence showed that he had a lot of blood on his right sleeve, I believe, along with mucus, which indicated that he had done most of the stabbing to her face and lung area.
There were a lot of other injuries, weren't there?
There were.
Okay. And did anything about the pipe or any of the other forensic evidence contribute to what you just said about that particular defendant being the lead person?
Well, the pipe was found at that particular defendant's home, I believe, and the pipe could not be connected directly to any of her injuries in terms of the forensic evidence that was found on the pipe. In fact, in the state's brief, they cite to the blood spatter that was on Mr. Hilt's clothing, that there was some on the front, but also some on the back, which to me indicates that he was not facing the victim when the stabbing initially occurred, at least, or some of the stabs occurred. Because of the particular kind of different fact scenario that this case has with regard to her relationship to Mr. Hilt, the text messages that were occurring beforehand that didn't show any ill will towards her necessarily, that he was just looking for a ride. It didn't seem like he was trying to lure her anywhere. He was looking for rides from a lot of different people, so that also indicated that he had no plan to kill her. This specific instruction that the mere presence, I believe, was needed to help the jury kind of muddle through the facts of this case. And it was the mere association with the principal, that instruction is a proper recitation of the law, the case law, and I think it would have just helped the jury with the aiding and abetting instruction to clarify some of the words that are in the aiding and abetting instruction that he intentionally must act and whatnot, but it clarifies a confusing situation for the jury. And I think that without that instruction, there is a distinct possibility that they would have been confused.
Is there anything that sets this case apart from the long line of cases where we have said, that that's not error to give for example, in Edwards, we said it would have been appropriate and would probably be a better practice, but we still found that it wasn't error. Why would this be any different than Edwards?
I think in this case it is different because the forensic evidence and the text messages and that type of evidence beforehand didn't implicate Mr. Hilt as much as the main defendant, Joe Maddox, I believe is his name. And so with this type of evidence being incorporated with the aiding and abetting instruction, I think there would be a distinct possibility for confusion with the jury. So just the evidence generally, I think, warrants this instruction more so than maybe in other cases. On top of the fact that it's the defendant's defense that he was just there, and that Mr. Maddox basically went a little crazy and killed the victim. The second issue...
I just want to clarify. You're saying that the instruction also was necessary to complement defendant's theory of defense?
Yes.
Okay.
The second issue deals with an interesting situation involving some juror misconduct. We believe the district court erred in dismissing the particular juror that was in question and replacing the juror with an alternate. This decision is reviewed by this court for an abuse of discretion. But this situation was a bit different than other juror misconduct situations I've seen in the past where this particular compromised juror, quote unquote, denied making or doing anything that the other jurors accused her of doing, which was, I believe, bringing in outside information into the deliberations. In her discussion with the judge, I think she indicated that she might have just made a comment about her belief towards the defendants, that they were a bunch of thugs kind of situation, but that she didn't review any newspaper articles or go online or anything like that. So she flat out denied the misconduct. The other jurors, even though they said that she had brought in this information, said that they could disregard what she had said and continue with their deliberations. The most troubling aspect of this is that one of the jurors said that they believed that the other jurors that were ganging up on this compromised juror because she had a different viewpoint. And maybe they were trying to get rid of her because it would be one less person to sway in the jury room. So
do you have anything in the record, counsel, that indicates that the different viewpoint held by the juror removed would have been favorable to your client?
Well, considering they eventually convicted, I'm thinking that might have been a favorable viewpoint, but
Do
I'm
we
not
know
sure.
how long it took them to convict after the replacement of the juror?
If I remember correctly, it wasn't that much longer after the replacement juror, but I don't know. Off the top of my head, I can look at the record and come back with that, those specific timelines.
We just don't have any direct evidence on that point.
No. And the juror that was speaking to the judge about this, she was very careful not to say which way that juror was going. The other problem is Mr. Hild's attorney objected to the alternate juror being put in place because she was not kept in the same situation, or she was not kept in the same posture as the jury. She was sitting with, not with them, but near the victim's family, I believe, and on the victim's side, and so she could have
The judge questioned that alternate about whether there had been any conversations overheard, et cetera, correct?
I think he did, yes. And she said that she didn't hear anything.
And it was unanimous among the other jurors that the juror who was removed had engaged in this inappropriate behavior.
I think the situation was that only a few of them had heard her actual comments, if I remember the record correctly. And there were several different conversations going on in the jury room, and she was involved with a few others. It was an 11-1 decision to have her removed. The one juror that brought to light the interesting situation going on in the jury room, she said that she didn't necessarily want her removed, but she just went along with it. The fact that all of those other jurors, though, told the judge that they could disregard anything that they had heard, whether or not it was outside information or the the compromised jurors' own opinion, I believe that dissipates the cause that the judge needed to have to remove this juror. And for that reason, I would argue that the judge erred in removing that particular juror and replacing it with a alternate.
Counsel, before you sit down, will you be addressing any sentencing issues?
If the court would like me to, I can discuss any sentencing issues that you might have. As I'm sure you're well aware, we did supplemental briefing on the Hard 50 issue, and I hope you received my reply to the state's response yesterday. And if the court has any questions about that, I'm happy to answer those questions.
Any questions of counsel?
We did receive your supplemental brief yesterday, but I still need clarification in terms of drawing the line between procedure and substance. I'm not sure I understand exactly what you're arguing in terms of saying that it's a substantive change in light of the fact that it's potentially the same sentence that could be given. It's just a difference between the judge making the findings versus a jury.
Okay, and to answer that question, I think I have to go back to why the Hard 50 sentence would be unconstitutional to begin with, and that would be because we'd argue that under Apprendi and Alene, it's adding elements to the crime to increase the sentence. And whenever you add an element to the crime, that is a substantive change that can't be applied retroactively.
The old law was.
I'm sorry?
The old law was doing that.
The old law is doing that.
So we're at a different point in the analysis. We're telling you to assume that the old law was unconstitutional. And now we have this new procedure. So how is the new procedure a substantive change in your client's rights?
Because it is adding the elements of needing to find an aggravating factor and weighing that against mitigating factors. So it's adding two separate elements to the Hard 50 sentence.
In Gould, the Gould court found that upward departure statute was unconstitutional on its face. Would you argue that the Hard 50 is unconstitutional on its face by requiring judicial fact-finding?
Yes.
And then after that in Cody, this court clarified that unconstitutional on its face means it's null and void. And so there wouldn't be any mechanism by which Mr. Hilt could have been legally given the hard 50.
That's correct.
And so when they pass a law and make another mechanism, that's the only mechanism there is. It's not changing the procedure because there was no mechanism.
I would agree with that, yes, Your Honor. I know that the state in their reply brief to my initial supplemental brief cited a case from Florida. I'm sorry, it was a U.S. Supreme Court case out of Florida that basically dealt with that issue, and the appellant in that case argued that because there was no valid way to sentence him to the death penalty in place because it was later found to be unconstitutional, that any change to that would be ex post facto, a violation of ex post facto, and the state argues that that is exactly what I'm arguing. I would say that that is just, it's old case law, it's no longer valid under Apprendi and Alene, and I'm making the exact same argument that Justice Johnson is making, that there was no valid way to sentence him to the hard 50 sentence because...
That wasn't Justice Johnson's argument, that was Justice Abbott in State versus Cody, 272 Kansas.
Yes, Your Honor.
Why do we have to decide this now? In other words, if we determine that the hard 50 is unconstitutional, it has to go back for resentencing. Mm-hmm. Why not go back and let you guys argue to the district court whether it's ex post facto and all that, and then let this percolate back up? I mean, it kind of occurred to me last night when I was thinking about this that we, assuming everything else is correct, mm-hmm. that we kind of have 25 years to figure this out for this guy. And so, I mean, why not do that?
Mm-hmm. I think it would be helpful to the lower courts dealing with the hard 50 fix to have some guidance from this court as to what to do. But if you wanted to do that, I suppose that would be well within the law to do that. But I would argue that because it's a violation of ex post facto, this court should just decide that issue on this case.
Give an advisory opinion in advance of anyone attempting to apply it to him.
Correct.
What does this do to the other hard 50s? I understand that your position is this was on appeal, so this is why this takes place. But what about the other hard 50s that were imposed prior to Aileen, or Aileen, however you pronounce it?
Mm-hmm. I am not sure.
If you're saying they were unconstitutional sentences,
mm-hmm.
what does that do to those?
I don't know off the top of my head what the process with that would be, other than the fact that they're final sentences now. But if they were, I suppose they could file motions to correct illegal sentences due to the unconstitutionality of the sentence. But
well, if I'm not sure a death penalty would get imposed if a death penalty statute's found unconstitutional and someone received that and they're still awaiting that sentence to be imposed. Mm-hmm. Would they?
Your Honor, I'm unfortunately, without further research, I don't know if I could answer that question with certainty.
Do you have any further questions of counsel? Thank you, counsel.
Thank you.
Good morning. Steve Howe, Johnson County District Attorney, appearing on behalf of the state of Kansas and State v. Hilt. I'll start with some of the arguments that were made earlier today. First one on aiding and abetting instruction. This court mentioned the fact that one of our arguments is there's never been any statement made by the defendant at any point in time highlighting why his particular situation is different than any other co-defendant aiding and abetting situation. And because of that, we think it's important that you follow the PIC instructions on aiding and abetting instructions. There's nothing distinguishable from his set of facts from any other case. I wanted to clarify a few things that were said by counsel during the arguments. One of them that there is no real evidence of his participation in that. We did have a snitch testify from the jail that Mr. Hilt indicated that if I couldn't have her, no one else could, and that he got rid of the evidence. And so there were some statements indicating that he did participate in it. The other thing is in regards to the bloodstain spatter evidence, and one of the major point of contentions were based centered around Mr. Maddox had more blood on his jacket than that of Mr. Hilt, and therefore the argument made by the defense was that Mr. Maddox was maybe the lone, if not the major participant in the act of violence against Ms. Keely Allier. The bloodstains pattern reenactment highlighted exactly what we thought it would say, which is unlike on TV on CSI where someone's blood soaked, that you can commit a violent crime against somebody and not be soaked in blood. The blood spatter analysis reenactment demonstrated the same type of bloodstain spatter that was on Mr. Hilt's jacket and other clothes. And
Mr. Howe, I'm just
sorry.
curious, was that experiment ever challenged on the basis of Fry?
It was.
It was.
It was challenged. We had a hearing on that. We had testimony as to the evidence and why it was supported by scientific theories. You know, basically it dealt with the issues of gravity, scientific analysis, mathematics.
Had that type of test utilizing had that ever been done before, or is this something that was just created by this forensic person?
No, this is a science in the area of crime scene investigations. It's been done for a considerable period of time. There's testimony about that, that there actually, before she did her experiment, she consulted with a couple experts in the field, including, believe it or not, one of the best experts in the entire country is at the KBI here in
It's just, again, outside looking in on appeal, it just seemed odd that they didn't even utilize the same, not only the same type of knife, but the blade length was considerably different. It just struck me as how does that recreate what it's intended to recreate when you're using a completely different instrument?
And when I tried this case, I was also involved in Pennington, which addressed the issue of reenactments. And in Pennington, it was dealing with whether somebody could hear a gunshot from a location inside the house. And so in Pennington, which I actually was involved in, we did a reenactment where we discharged a similar gun. And what the court said in that case was it was substantially similar, and that was a factor for the jury to make a determination and weigh what credibility to give. The court has discretion to make sure that there is some relevance to it, that it is substantially similar, that it's a material matter in dispute. The court found in this case that it was. Part of the defense, again, was that because Mr. Hilt didn't have a lot of blood on him, therefore he wasn't involved in the crime. And what it did show, and one of the comments made by counsel was, well, he had some blood on his back. Well, what it showed was when you stab somebody and the knife comes back, you have cast off. And the very cast off that he had on the back of his sweater was demonstrated on the hoodie that was worn during the reenactment. So, and also he had blood stains on his cuff, and it was also consistent with having on the reenactment. So there was actually a lot of relevant evidence. It was very consistent. The court has within its discretion to rule on admissibility of those types of things, and he found there was enough similarities to make it relevant evidence in this case. The next issue was on jury replacement. I frankly think that Judge Davis did an excellent job of vetting this process. He did as good as he can do, which is he met with each of the jurors and asked them individually what happened, what did they know about any violations of his instructions to the jury. In each and every instance, other than the offending juror, each juror indicated that the offending juror was making comments that was outside the evidence that was presented or was violating the court's prior admonitions. One of them chiefly being don't talk about media reports. The court discussed that on numerous occasions and advised the jury not to do that kind of stuff. That juror had blurted out several things related to that. The juror was also indicating things that was not part of the evidence, which the juror said, trying to stop that juror from mentioning that before and after deliberation started. And really, I think what this case highlights is should give us some faith in the jury system, that you've got 12 jurors in there, and that is not an easy task for them to want to vote somebody off the island, so to speak, and to take it upon themselves. I mean, that's a pretty serious act by them, and for them to take that and say to the judge, we want this person kicked off the jury. In any case, they took their job very seriously, and I think it should give us some faith in the jury system that they took their job so seriously. They indicated to a judge that one of their own was not following the rules. And then, if you look at the process, the judge weighed what options he had available to him, and he made the decision to remove that juror and place the alternate juror in her place. And I think he did it with due cause, and under the rules that had been set forth, he acted appropriately in this case, and I think there's no cause for error on that issue. I would be happy to go through other issues on the trial phase, but
What do you have to say about comparing this case to the movie Goodfellas?
Goodfellas. I use that as an analogy. I'm the trial counsel in this case. It was one mention to give paint a picture basically of what happened. And when I made that analogy, it wasn't just because I did it just to mention a gruesome movie. I did it because the facts fit that version in the movie. And so I didn't do it as an off-the-cuff comment. I made it one statement.
Well, the facts, talking about the facts, seems to me, as I recall, you actually talked about that in the movie the victim is pounding on the trunk trying to get out, and while you didn't say that happened in this case, didn't you essentially imply that? And since we don't know really what happened in this case, couldn't that put a picture in the juror's mind that was just totally improper?
It was a reasonable inference, I believe, on the facts. If you look at the evidence in the trunk of that car, number one, we knew that she was not stabbed or beaten in that car because there were no spatter evidence in the trunk. But we do know that she was injured and alive in that trunk because she disconnected the taillight assembly, and it had blood on it. So we know that she's hurt and she's alive in that trunk. There are also, the only stains on that trunk were transfer stains. Transfer stains would be if you had blood on your hands or something, transfer stains on the sides panels of the trunk, on the lid of the trunk. And so I think it's a reasonable inference based on that evidence that this was transfer stains by somebody who was alive and moving in that trunk. And I think it's a reasonable inference to say that she was trying to get help and trying to get out of that trunk. And I think it's a reasonable inference to make based on those facts. The other thing is...
Well, just to finish up, it seems like you also said something, I mean, in Goodfellas, and my memory may not serve me right here, I think you said something about the fact that they thought she was dead. And turns out she wasn't, and that's when she's pounding. I mean, I just think that whole scenario was one that we don't have here. We don't have any idea whether they believe she was dead, whether she was pounding on the trunk. It's just such a dramatic picture. It troubles me.
This was a pretty dramatic killing, too, and clearly there were separate attacks, and the physical evidence in this case established separate attacks at different times. And it also established that when her body was found, that was not a location where the attack took place, because there was no spatters, no evidence to indicate that the attack took place where her body was located. In fact, the pictures of her body clearly indicated as if someone would grab her legs and arms and toss her into the foliage. So I think we had solid evidence that there were two separate attacks at two separate times, and part of the phone evidence that we used is you knew when the attacks were happening because guess what? All these guys who were using their phones and texting and calling, there were no calls being made at that time. And so there was a dead time, so to speak, where that was when the deeds were being done against Keely Allier. So, yeah, do I have direct evidence? No, but I think I have a reasonable inference based on the physical evidence that we have that is how it played out. And in fact, if you recall, Judge Davis at the sentencing phase adopted that scenario as what happened. And if you look at his statement in his hard 50 findings, he basically agreed with the state's contention that the facts that we laid out is how that death occurred. So I think it's not just me making that statement, but Judge Davis also found that sequence of events took place in that way. Going on to, I'm going to address the hard 50 issue because you asked us to brief it, so I think you have an interest in wanting to discuss this as well.
Counselor, the way on the hard 50, the way I'm reading the argument on procedural versus substantive, it all hinges on a sentence you have here in the page 12 of your brief. The hard 50 sentence was plainly a potential sentence when he committed his crime. Now, if the statute, hard 50 statute, was unconstitutional on its face, then the hard 50 sentence was not plainly a potential legal sentence. And you heard what I said to opposing counsel. When you look at Cody, it said Gould was found the departure statute unconstitutional on its face, and if it's unconstitutional on its face, then it's null and void, and if it's null and void, it wasn't there, and there was no procedure, legal procedure, by which he could have been sentenced at that time. And so when we do the retroactive procedure, we're adding something that was not legally there when it was done. Do you understand what I'm saying?
No, I understand your argument, and that argument was made in Daubert. And that very argument was made and said, well, then we didn't have a law, therefore you can't retroactively apply it because it becomes
I'm talking
sensitive.
about in Kansas,
sure,
in our case law, where we said if it's unconstitutional on its face, it's null and void.
Well, but in Daubert, they made that same pitch, and the U.S. Supreme Court said no. That and part of the language they said was that the defendant was provided a fair notice of the penalty, and therefore we're not going to impose the ex post facto clause against the state in that case. So I agree that is a very logical argument that was made in that case, and the U.S. Supreme Court said no, we're not going to apply it in that way. Starting out with, I would say that I strongly believe that Elaine does not apply. And if you look at the language of Elaine, it talks about the fact that mandatory minimums in those types of situations, basically if we had a guideline case like we have here in Kansas.
Counsel, I'm sorry to interrupt, but you have so little time left. I want you to address a question for me. And it's the question my colleague at the end of the bench asked during your opponent's argument. Why now? Why do we address any of this on Hard 50 now?
Well, why now is because I think the court recognizes that there is a number of cases that are currently pending that have a dramatic
There's a
impact.
pragmatic aspect, and that's the only reason that you would give us.
No. I also think part of our job in the criminal justice system is to make sure that we effect justice in a timely manner. Instead of these cases bouncing back and forth, I think it's highly appropriate for the court, knowing that the number of cases that are going to be before you, that you try to take care of this in a timely manner to give some direction to the district court judges, give some direction to the trial attorneys. And even though the defendant may be serving time and may serve up to 25 years before we have to worry about his parole eligibility, depending on how you rule, the bottom line is I think in order for us to effect justice and to provide some guidance to the victims' families, the defendants, and people in the criminal justice system, you have a busy docket, and having these cases bounce back and forth only delays a ruling. It creates more work for you. I think by you making a timely decision on this case and giving direction to all the people in the criminal justice system, I think you aid not only yourself but everybody else in the system. So that's why I think it's important for you to make a decision now.
And just to be clear, counsel, you think we should make the decision now on the ex post facto element?
Yes. I think both on whether or not Elaine applies, and I think also whether or not, if you find that Elaine does apply, whether we can retroactively apply this new law to these old cases. But I think the important thing about Elaine is that it was talking about determinate sentencing instead of indeterminate sentencing, and life is life. And if you look at some of the cases that we cited in our brief, the parole eligibility of an individual is not the driving force. It's what the actual sentence is, and the sentence is life in prison, whether or not you get the hard 50 imposed or not, and therefore Elaine does not apply to these facts in Kansas. Now, granted, we did ask the legislature for a special session, and it's because we're hedging our bet, because I'm not saying that I can predict how this court's going to rule, and basically we felt that these cases were too important in the state of Kansas for the public safety to just bet on the fact that you're going to rule our way as far as Elaine's application to the hard 50. So we hedged our bet and changed the law so we'd have a backup position if you found otherwise.
Hasn't the state argued inconsistently with that position you're taking now before? That this is a mandatory minimum, essentially, that doesn't apply because this isn't a mandatory minimum.
Have we argued otherwise?
Mm-hmm.
I can't think of one off the top of my head.
Well, I think you have. I mean, I think that's been the argument as to why, in talking about, I'm trying to think of the case, but where we talked about the hard 25 and the fact that it's a mandatory minimum, so Apprendi didn't apply.
Well, when Harris was
and
good
Harris,
law.
right.
Harris was good law. The argument was that
yeah.
this was a mandatory minimum,
Yeah.
and
I mean,
aren't you just
some
taking a
people may have
totally
made
different
that-
approach now that it's not?
Some people may have made
Is
that
it-
argument, but I think if you look at our brief and the case law that's cited, I think clearly that it doesn't apply. And so I think our brief sets forth what the Supreme Court's intent was when they sent these cases back down. And I think it also supports the proposition that Elaine applies to determinate sentencing, not indeterminate sentencing. And if you look at the cases that we cited, parole eligibility is not considered to be part of determinate sentencing.
So why have a hard 50 then? If life is life, what's the point of having a hard 50?
Well, but it is an indeterminate sentencing. The parole board makes an independent decision.
Right.
It's just like when you say life with eligibility at 25, that doesn't mean that you get out of jail at 25.
Correct.
Because I have appeared on a lot of parole boards, and a lot of people get passed on parole. So I think that's the distinction, is that because it's indeterminate, because there's a possibility of range there, they're not going to apply Elaine to the hard 50, or it shouldn't be applied. It would be different if we said life with parole eligibility at 25 and you just got out at 25 and that was it. But that's not what happens in Kansas. The parole board, an independent body, makes a decision. It's not the trial court, it's not the appellate courts, it's the parole board that makes that independent decision. And if you look at the cases cited in our brief, they basically say that indicates an indeterminate sentencing. It's not a mandatory minimum, which Elaine, if you look at the specific language in Elaine, they talk about mandatory minimums, because that was a gun case where basically the court had no option but to impose that sentence because of a mandatory minimum structure of their sentencing guidelines. And so that was the deciding factor. And the court in Elaine specifically distinguished that type of sentence from what we have here in this case. I think I'm out of time, but
I'm still, if Elaine doesn't apply, in order to impose and so you're arguing that the prior law was effective?
Yes.
So how do you get around the judicial fact-finding in order to get to that conclusion? Isn't that the problem with the prior law, was the judicial fact-finding?
Well, it's judicial fact-finding where the court has some discretion to make that decision. And in Elaine, the court had no discretion, and that's where they made a clear distinction.
The discretion isn't in the fact-finding. The discretion is in what you do with it.
Right.
Isn't that
correct? Okay. You're right.
So really the flaw that the U.S. Supreme Court keeps hammering away on ever since Apprendi is in the fact-finding, not in what the judge does with it.
Or that the court can do that the court has an option.
Right.
I mean, that's basically what it boils down to.
I think that's what my colleague's driving at.
Right.
The problem's the fact-finding.
Yes.
Yeah.
And you don't have an answer to that. because you acknowledge that. The problem that the U.S. Supreme Court's identified is the fact-finding by the judge.
Yes.
On a standard other than reasonable doubt.
Yes.
And you're arguing, well, but the judge has discretion, but the judge doesn't have discretion until he or she has done the fact-finding that's causing the issue in Washington.
But I don't think Elaine said that necessarily it was the fact-finding that was the problem. I think it was the fact that the
mandatory nature afterward.
Yes.
Okay, got you. Thank you.
Any further questions of counsel? Thank you, counsel.
Thank you for your time.
Just wanted to clarify a few factual questions. I believe Justice Beyer asked how long after the new juror had been put in place did they decide the case. She was put in place sometime after 10:25 or so, and then they came back with a decision at 2 o'clock that afternoon. One other factual disagreement I have apparently with the state about the forensic blood spatter experiment. The forensic person over at KBI said that she did not consult with any experts prior to the experiment, that she had talked to them about other aspects of the investigation, but not about this particular experiment. And we do have a number of problems with that experiment, including the length of the knife, the type of knife, the amount of force that they had to limit because of potential injury to the forensic person. Bloody sponge, I don't think in any way seems like a human body with skin. That argument was also made. Going back to the hard 50 argument.
But you're not actually bringing a Frye challenge on appeal, are you? I mean, that's not the argument we're looking at on appeal.
No.
Okay.
I'm arguing that this evidence was far more prejudicial than probative.
Okay, thank you.
Yes. Because the experiment was very dissimilar to the potential facts in the case. I believe that the Elaine court did have a problem with the fact-finding in this in the mandatory minimum cases. They discuss how the facts should be found beyond a reasonable doubt by a jury, and that the current status or the current statute in Elaine was preponderance of the evidence by the judge. And so there was a problem with that fact-finding not being constitutional because an element should be found beyond a reasonable doubt by a jury. And that concludes my
I understand that your position is that the sentence wasn't constitutional in the first place, but aren't you, in essence, what your position is, or what I'm having trouble with, is that your client received the hard 50. It was deemed not a proper sentence, and now he's being sent back to be exposed to the same sentence, but with greater safeguards, in essence. I mean, isn't this legislation actually create greater safeguards for your client than what he had in the first place?
Practically speaking, it does, but I would argue that he should not be exposed to that sentence at all because it was found unconstitutional. It should be found unconstitutional in the first place.
I understand that's basically your position, but otherwise, it really is a procedure with greater safeguards than what he was initially exposed to.
Correct. For future defendants, that's especially true. I know my time is out, but I would just like to draw attention to issue 9, which is the cumulative error issue. And I raised lots of issues in this case that hopefully you would reverse on, but if not, I believe the cumulative effect denied Mr. Hilt a fair trial.
Any further questions of counsel? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Clerk will take this matter under advisement. Now turn to the next case on this morning's docket, which is case number 105828, State of Kansas versus Dwight B. Cameron.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm here today on behalf of Mr. Cameron. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, my plan today is to talk a little bit about the lesser included offense issue with regard to felony murder, and as time permits, maybe a little bit about the hearsay issue, and of course whatever else the court would like to chat about. The first issue in this case has to do with the failure to give a lesser included offense of involuntary manslaughter in this felony murder case. We all can have a certain level of empathy for Judge Waller in this case, and that Barry came out after the trial in this case and did change the law somewhat with regard to the felony murder rule. But that certainly applies in this case, and so we're dealing with that. And I sort of recognize that with regard to this issue, as I was reviewing this, getting ready, it seems like that I acknowledge maybe the court isn't of one voice on this, or one clear voice, maybe I would respectfully submit on this. But I think that this is the analytical approach that we should take. We have to decide whether the lesser included offense was legally appropriate, and then determine whether it was factually appropriate.
Okay, and let's jump in. Why is it factually appropriate? And where is there any evidence of recklessness here?
And when we do this factually appropriate analysis, my understanding of the majority of the court at this point is that the test is, had Mr. Cameron been convicted of involuntary manslaughter, would this court have reversed for insufficient evidence? That's the test and Haberline and cases after Haberline that this court has established. And so the answer to the question then, Justice Rosen, is it's not, we shouldn't be looking at, for example, what his defense was or things like that comparison, because that's irrelevant to the question of whether there was sufficient evidence of involuntary manslaughter. And so the question is, assuming, again, I have to take the facts here. I'm not conceding anything on my client's behalf, but taking these facts here is the state's evidence that my client repeatedly struck this child many, many times, eventually causing this child to die. That's the state's evidence here. And the question is, faced with those facts, would this court find insufficient evidence to support a conviction for voluntary manslaughter under those facts? And I submit, of course not. The problem here is the state is really arguing this strongly in this case, but we don't know the state of mind of the person. And the fact that there may be intentional conduct on part of a person does not mean that there's intent to kill, which is a requirement for first or second degree murder. Killing somebody without intent to kill is involuntary manslaughter, or maybe second degree reckless murder. And so that's where the problem here is. This court has said, under circumstances similar to this, that a jury might infer intent to kill, and that, I think, is probably true. But it doesn't necessarily mean or exclude the possibility that a jury could conclude that they have a reasonable doubt whether there was intent to kill, as opposed to somebody acting out in some sort of angry way, or whatever the situation is, not intending to kill, but actually killing. And what is that? That's involuntary manslaughter. If somebody does something knowing, we should all be able to say that you knew or should have known that this kind of conduct could result in the death of somebody, and it did, that's involuntary manslaughter. So even the state in its brief, Your Honor, recognizes that, is making this idea that ordinarily a person, you can infer from a person's conduct their intent, and that's fine, but it's not that it necessarily is the case and excludes the possibility of any other conclusion. And that's your question, is could a rational jury have said, we have a reasonable doubt whether or not Mr. Cameron intended to kill the victim in this case? And if that's true, then there was sufficient evidence to support a conviction for involuntary manslaughter. If that's true, and I think the record makes it abundantly clear that that's true, then it was error to not give the instruction. As I understand this court's analysis and agree with this court's analysis. The turning then is, do you reverse then on that? And that's a distinction between this case and maybe some prior cases, because in some prior cases of this court, there was no request for the instruction. This is a requested instruction in this case, and therefore I'm not dealing with clear or anything like that. We should be looking at a straightforward analysis. And in fact, I actually, as I thought about this analysis, it seems sort of redundant to me to apply a harmless error analysis when you're dealing with a requested instruction, because you sort of built in the harmless error test to your evaluation of the evidence already. I mean, if a reasonable juror could have found involuntary manslaughter, then a reasonable juror could have found involuntary manslaughter. And so I'm not sure when it's a requested instruction, what additional step the court would have. But that's our position on this, that applying this court's analysis, that it's...
What's the when this do you just automatically get an instruction when it's requested, even though the facts may or may not? It takes rather a speculative, creative view of the evidence to get to the requested factual instruction, to factually support the instruction. Basically, if you request it, you get it?
If the evidence supports the lesser, would support a conviction for the lesser.
And here I'm still having trouble. When you're in conference requesting instructions, what evidence was pointed to that supports the instruction? I just didn't see it, and I don't see it looking on my review of the facts. I don't see where it was in the request where it was articulated what facts support that instruction.
So
you request it, you get it?
If the evidence, no, I'm not denying that the evidence has to support it. Our argument is evidence of somebody taking an action like this, repeatedly striking somebody, a particular young child, even if they don't have the intent to kill, that they knew or should have known that it could cause death. That's reckless behavior.
Actually, the evidence was used here to convict him of felony murder. They said he was committing child abuse. Not that he intended to kill, but that he was committing child abuse and that the child died as a result. So the state actually used that absence of intent to kill to get a first-degree murder conviction.
It's a part of the reason for the felony murder rule. That's to be certain. And to try to answer your question, do you automatically get it? I think in a lot of cases, a lot of felony murder cases, at least where there's an issue with regard to intent to kill, then yes. Okay. In a lot of cases, you are, if you request it, going to be entitled to this lesser included offense instruction, because in most cases where there's a question with regard to intent to kill, then the evidence is going to support, assuming that conduct otherwise supports a finding of recklessness, will support that lesser included offense instruction. I can't say for sure in all cases where the only theory is intent to kill. I would honestly answer your question. I think in most cases that I can imagine, the answer still would be yes, because intent is almost always something that you're gleaning from other evidence. And the concern is, do we always know unequivocally without possibility that there's intent to kill as opposed to something less?
Mr. Hodgkinson, this is the part I'm struggling with on reversibility, because it is a felony murder as opposed to a pre-med. I mean, felony murder really kind of excuses the state from proving up intent, doesn't it? Intent to kill.
It excuses this. They don't have to prove intent to kill. That's right.
So I can understand your argument on when what you're saying in essence to me is when there's an absence of direct evidence of the state of mind of the defendant, then it is pretty much virtually automatic that when you're charged with first-degree pre-med that you'll also get some lessers. But when you're convicted, let's say you're right on all that. Let's say we accept that. You start dealing with felony murder here. And in felony murder, that doesn't have to have been proved. So how was your client prejudiced?
But there are different things that have to be proved, particularly, and this is one of the issues that we're talking about in another issue in my brief. It has to do with, for example, causation, temporal proximity. All of these other issues go into whether the predicate felony caused the death and things like that. And so that's a separate issue in my case. And even if you disagree with me on that, the jury is still making findings regarding that. I think we all have to admit that it is possible for a jury to decide that a death did not occur as a result of, by whatever standard the court sets, the predicate felony. And if that's the case, and that's in fact the whole purpose of Berry, is the idea that there could be lesser included offenses, and for example, in this case, had the jury been given the lesser included offense as requested, then they would have been comparing these things and trying to decide. And even if you reject my claim that there's insufficient evidence of sort of the temporal link between the predicate felony and the death, that's still something the jury would have been considering and could have reasonably said, well, we don't know that it occurred during, if we would really read the instructions carefully, that it occurred during the commission of. So is there an alternative? And if there was a lesser given, then there is an alternative.
Okay, I understand. Thank you.
And can we, what about the legislative changes that have occurred since this conviction? You want to speak to those?
Sure. I think this court has already said that those legislative changes don't apply retroactively, that it would be an ex post facto violation.
What's ex post facto about this? What's the greater sentence that, explain to me your ex post factos.
Well, it's a substantive. It would be a substantive change.
Doesn't it require an increase in punishment?
That he was entitled, if you agree with me, and as far as Barry says, if he's entitled to the lesser included offense instruction under the law in existence at the time of the offense, then he's entitled to that now. And to the extent that the legislature went and changed and said there are no lessers now of this, one, as this court noted, there's some constitutional ramifications of that, and two, there's no doubt that's changing the nature of the crime to disadvantage, if you are applying it in this case to Mr. Cameron. That's it's not a sentence issue.
Right.
It's still disadvantaging Mr. Cameron. That's explicitly why they did it. And they can't do that retroactively.
What's the constitutional disadvantage? I mean, we're talking about lesser includeds, aren't we? There's not a constitutional right to lesser includeds, are there?
Well, this court said maybe there is.
Maybe. Explain to me why there is.
It has to do with
constitutionally. I mean, this all flows from statutory creations. So why is it why does it implicate the Constitution?
Okay. We haven't briefed this, and if you want to order us to brief that, I'll be glad to do that. But I can't answer your question, which is, I think there is a constitutional issue with regard to the due process clause and the jury trial clause, because if there is are lesser included offenses that are available and appropriate as a matter of state law, then who should decide between them? And it's under the United States and I think the Kansas Constitution, the jury's job. Under the due process clause, under the jury trial clause of the United States Constitution, and under the jury trial clause of the Kansas Constitution, it's the jury's job to make that distinction between them. And failing to give the lesser included offense interferes with that jury's right and my client's due process right to have an accurate determination of what the offense is in this case. That's my short answer. I could develop it a lot more if the court directs.
Sure you could. Yeah.
Any further questions of counsel? Thank you,
Your
Counsel.
Honor.
May it please the Court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. As opposing counsel did, we will be confining our discussion today to the first issue. To the extent the Court has any other questions with regard to the other issues, I'm certainly happy to address those. The first issue challenges the Court's refusal to issue the instruction for reckless involuntary manslaughter as a lesser included of felony murder. At the time of brief writing, in this case, Barry was the applicable standard. In the interim, the legislature has come along and amended two statutes to indicate that there are no lesser includeds of felony murder and that it is, in fact, retroactive and applies to cases pending on appeal. So it would be the state's position that that being the latest pronouncement of the law, that would be what would control in this case, and he would not be entitled to lesser included offenses. That way, the only mechanism for him to obtain the relief that he seeks is to establish that this is an ex post facto violation, and I would acknowledge that the parties have not briefed this issue, so kind of a surface discussion, it would be the state's position that there is not an ex post facto violation established because the two-part test hasn't been met. Does it go back in time? Yes. But has he been disadvantaged? No. It doesn't affect the crime charged. It doesn't enhance the punishment that's prescribed for the crime, nor does it adversely affect the quantity and the quality of the evidence that's required to establish guilt for the offense that's charged.
I don't understand how it can't affect the crime charged, because if you instruct on lessers, then the crime charged is this or this or this, and if you don't give the lesser, the crime charge is just this.
But it doesn't affect the elements of the crime that he's been charged with. It doesn't affect the substance of the crime that he's been charged with. The amendments have not altered that crime specifically in any form.
Essentially, you're saying the prosecution can still choose to, whatever crime they want to charge, and it's the elements of that crime that they charge that are important in the ex post facto violation.
Correct. All that has happened with respect to these amendments is it regulates the steps that are to be employed to determine how he or what criminal statute he has violated, but the actual substance of those statutes has not been changed. To the extent this court determines that the amendments do not apply and that Berry is the appropriate analysis, the state would argue that he also is not entitled to relief under that analysis. Under Berry, a lesser included instruction is given when there is not just sufficient evidence, but whether there is a reasonable probability that the jury would have convicted based upon that evidence. If we're going to look at just the evidence, then any time a person dies, we're going to say, well, that's a lesser included because there are commonalities, because in fact a person died. But that borders on the ridiculous to some degree. We have to look at whether it's reasonably probable that a jury would have convicted of that lesser included crime. And when we apply that analysis to this case, we don't get there. The child in this case suffered 20 blunt force injuries to his head alone and 40 to his body. The unrefuted medical evidence was that this was intentional, that there was nothing accidental about these injuries. They analogize these injuries with that would be sustained in a bar fight and in a car accident where the child wasn't even strapped in but was battered about the vehicle. There is nothing accidental about these injuries. Did he die? Yes, he did, and that's unfortunate. But is it reasonably probable that a jury would have found that this was a reckless act? And it would be the state's position that that's not possible under the facts of this case.
Is it the act that has to be reckless? I mean, the intent, the idea is that you intended the act, but what was reckless was the intent to kill, isn't it? Haven't we clarified that reckless doesn't mean that it was an act that happened recklessly, but that it was a reckless disregard for whether death occurred?
It's recognizing the imminence of that danger and then acting in conscious disregard of that danger. And we don't even have that here. There's no acknowledgement that he recognizes that there was a danger. He's basically saying this was just an accident, that I got out of control and I beat this child excessively. He doesn't even argue that he recognizes that. In fact, he says he was shocked and dismayed. That's not a recognition of his recklessness. Again, the facts in this case support only the finding of the greater crime. A reasonable jury would not have convicted of a reckless act in this case. And for that reason, the state would respectfully request that these convictions be affirmed.
So just to confirm, I guess you don't agree with Mr. Hodgkinson, that Haberline, I think how he phrased it was that he viewed Haberline as saying that if essentially we would have found evidence of involuntary manslaughter sufficient, that we essentially have to approve a lesser included here.
I think that dilutes what we're looking at. I think you have to look at not only the evidence, but whether a reasonable jury would have looked at that evidence and convicted of that crime. I think it's essentially two parts, and I think that's kind of been excised out in opposing counsel's argument.
How does that keep us from being the jury? If we make a determination of what's the appropriate crime to convict of. I mean, you're saying we need to look at it and say, well, the jury should have convicted on this, of this crime because here's the evidence. I mean, why isn't that taking it away from the jury to make that determination?
I don't think it is taking it away from the jury. I mean, if we're essentially looking at this in the position of the district court, and we don't look at it, I guess, in a vacuum. We don't look at it strictly on the elements, but how the jury is ultimately going to view that. I mean, I guess can't really formulate an answer to your question other than it's not. I mean, I guess you would say that with respect to any time that you're going to issue an instruction. Why then don't we always give the full panoply of instructions that are available? Because there are going to be certain situations where it simply does not fit, and that isn't the court taking the place of the jury. That's the court's responsibility to help make that assessment and to apply the law to the facts and determine what's appropriate to give to the jury.
Ms. Isherwood, I just want to make sure I'm clear on your position. I understand your focus on whether a jury would reasonably convict. I understand that you're trying to make sure we don't forget that part of the standard. But here, the evidence that you say makes it impossible that a reasonable jury would have convicted of a reckless crime is the number and severity of the injuries. Correct?
Yes.
Okay.
Anything else?
I think you have to look at how those injuries came to be. I mean, if you're going to say this was reckless, which one of these injuries? At what point was it reckless? I mean, we're talking about a total of 60 injuries in this case. You have to look at the manner in which they're delivered. It's not just their existence, but how it is that they came to be. And it's simply when you get to that point and you look at the act that produced those injuries, that is not a reckless act. That is not accidental. When you look at a child of this size to inflict 60 injuries.
I think we're talking past each other, because if you're going to say that the act itself is reckless, then your argument is very understandable. But if you're saying that the reckless portion means reckless disregard of the consequences of intentional acts, like beating a child, and you disregard the imminence of death that can occur, but you still are intentionally beating the child, then your argument doesn't make any sense to me.
I guess I don't understand where...
Well, you're arguing that reckless is synonymous with accidental.
Because that is pretty much how this court, when conducting analysis of like cases, that's the manner in which, that's the approach it has also taken.
Are you arguing that when we look at the probability of the jury verdict, we're saying that it's unlikely that they would have ever moved past finding that there was child abuse and felony murder as a result of child abuse?
Based on the facts of this case? Yes.
Or are you saying that we would find that it's reasonably improbable that the jury would have convicted of reckless? I understand what I'm saying. Are we talking about it at the first level, that they would never consider it, or are we saying that if they consider it, they wouldn't find a reckless murder?
I think it's more the latter. I think basically the way this court has interpreted lesser included is I think it's more the latter.
And that's the way you're arguing it as well?
Yes.
Because I wasn't sure if you were stopping at that first step. Or...
No.
And the defense in this case was that, I thought it was that I didn't, if these severe injuries I didn't do because all that I witnessed was him falling out of bed.
It was kind of a multifaceted thing. It was a fall in the tub or from the toilet. It was possibly his younger and older sibling, or it could have been the mother. So there were about 3 different things that were going on. There was evidence presented that at the time that the witnesses came in and first made contact with him, that it was an explanation for 2 different falls. There was evidence that came in that he said, well, perhaps, it was inflicted by wrestling about with a sibling or arguing with a sibling. And then there were also some intimations that perhaps it was something that was inflicted by the mother before she had left that day. So there are a couple different things going on.
Counsel, when the defense asks for a lesser included offense and the court is struggling or trying to decide whether to give the instruction or not, the court has to look at a certain amount of evidence before making a decision, correct?
Yes.
And from whose perspective is that viewed? Is it the light most favorable to the requesting party, in this case the defendant?
Yes.
And so it's your position that even looking at the evidence most favorably to the defendant, the lesser included instruction still should not have been given?
That's correct. Again, if there are no further questions, we would ask that these convictions be affirmed.
Any more questions of counsel? Thank you, counsel.
Yeah, I just had a couple points on rebuttal. One, and it's not really a rebuttal, but I just wanted to follow up with Justice Rosen's question that I don't think it matters with regard to this ex post facto, whether it's constitutional. Any disadvantage, even if it's a statutory disadvantage, would be enough to prohibit the legislature from doing something like this retroactively. So I want to be clear that I don't think that matters for the purpose of this.
Any disadvantage? Can a procedural, any disadvantage, then you're...
Any substantive disadvantage.
Okay.
Substantive disadvantage. My colleague noted that her belief that it's not reasonably probable that a jury would have come back with a involuntary manslaughter verdict in this case. That's not the standard. It's not her standard, and it's not your standard to determine to sit as a super jury and decide what's reasonably probable in a case like this where the lesser was requested. The standard should be, is there any evidence on which the lesser would be supported under the evidence?
For which a jury could reasonably convict, I think is a statutory language.
Any jury could reasonably convict. Not whether it's probable, even if it's the 1 in 100 jury. And Justice Lukert, if the lesser had been given in this case and the jury had been properly instructed, they would have been instructed, consider all of these things. You can convict of felony murder, you could convict of involuntary manslaughter. If you have a reasonable doubt between them, you can only convict of the lesser. So a jury, properly instructed jury, following the instructions, at least would have considered the relationship between those things. Why not give the jury the full panoply of lesser included offenses? To the extent that it's not reasonably probable that they will convict of the lesser, what's the harm? Why not let the juries do their work, as opposed to having judges make these determinations about what judges think are the best possible verdicts in these cases?
So what's the purpose of the statute? Why not just say, what's the function of the statute that gives the court some discretion or actually requires the court to look at evidence and then give the proper instructions? Why have that statute?
When you're dealing with lesser included offenses, to the extent, there may be some lesser included offenses where they're like voluntary manslaughter, where there's an additional...
Why not instruct on battery in this case?
Battery's not a lesser. It's not legally appropriate.
Okay.
So you don't give legally inappropriate instructions, but factually appropriate, that should be a jury's determination. To the extent that my colleague is right, that a reasonable jury wouldn't do this, then they won't. But if a jury did do it, and they would have done it, but they were prohibited because
my
the
trouble
judge...
with this, Mr. Hodgson, it really just, if you request it, then the trial judge just has to sit there and fantasize and speculate what can I imagine could be created from this evidence. And basically it's just, once you request it and facts are established that's within the realm of possibility, then you give it.
Then let the jury make the decision.
So
the jury is
essentially what you're
charged to
saying
make.
is there's really no screen, there's no filter, no nothing. as long as there's something that I can imagine, that I can speculate, you get it.
Yeah.
You don't speculate about the evidence, you speculate about the theory. The evidence has to be there to support it.
Evidence has to be there, and in cases where you're dealing with, certainly where you're dealing with like first-degree premeditated murder versus second-degree intentional murder, there's always going to be evidence of second-degree intentional murder. There's always going to be a question. The jury should be making the decision about whether or not there's premeditation, not a judge. In every case, every single case.
And this is not this case, but once you charge and prove or there's evidence of premeditation, then basically if someone requests lesser included based upon that, the finding of premeditation, you can create, basically you get every lesser included.
Every lesser that is supported by evidence of premeditation. Yes.
And that would be short of the defendant making a statement, yes, I intended to kill the victim.
Yeah, of course. I mean, we always have...
Anything less than that, you would get the lesser included instruction.
Maybe even in light of that.
Right.
Because the jury still has to determine, just because a person says that doesn't mean the jury has to even accept that. But we should be having juries make those decisions, not judges. This case is just a good example of it.
Any further questions of counsel? Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. The court will take this matter under advisement. This time the court is in recess for 15 minutes.